Hello, Council. Today's topic is selecting the seat of arbitration, a critical decision that can shape the entire arbitration process. When entering into an arbitration agreement, one of the first and most important decisions the parties will make is the choice of the seat of arbitration. But why does this matter so much? Let's explore the key reasons. What is the seat of arbitration? The seat of arbitration is the legal jurisdiction where the arbitration is based. It's more than just a physical location. It's the legal framework that governs the arbitration process. The choice of seat determines which country's arbitration laws will apply and how the courts can intervene, and how an arbitral award can be enforced. For example, choosing London as the seat means that English arbitration law applies, and any court challenges to the arbitration process would be handled by the courts in England. Why does the seat matters? Legal framework. The seat provides the legal rules that governs the arbitration. This include the procedural aspects of the arbitration, such as how arbitrators are appointed, how evidence is handled, and how the award can be challenged or enforced. Some jurisdictions have more arbitration-friendly laws than others, which can make the process smoother. Judicial support and intervention. The courts at the seat of arbitration have the authority to support the arbitration process in various ways, such as compelling witnesses to testify or enforcing interim measures. Conversely, the seat also determines the extent to which courts can intervene in the arbitration, which can be a double-edged sword. Enforceability of awards. The seat can influence how easily an arbitral award can be enforced internationally. Under the New York Convention, awards made in signatory countries are enforceable in other signatory countries. Choosing a seat in a country that is a signatory to the New York Convention is crucial for ensuring that the award can be enforced globally. Governing law of the contract versus law of the seat of arbitration. Now, let's discuss an important distinction that often confuses many: the governing law of the contract and the law of the seat of arbitration. Governing law of the contract. This is the law that governs the substantive rights and obligations under the contract. It's the set of rules that will determine how the contract is interpreted, what constitutes a breach, and what remedies are available. For instance, if a contract states that it is governed by New York law, then New York law will dictate how the contract is interpreted and enforced in the arbitration. The law of the seat of arbitration. This refers to the procedural law that governs the arbitration itself. It sets out the rules on how the arbitration is conducted, including how arbitrators are appointed, the powers of the arbitral tribunal, and the role of local courts. If the seat of arbitration is in Paris, French arbitration law will apply to these procedural aspects, regardless of whether the governing law of the contract is New York law. Understanding the distinction between these two legal frameworks is crucial because they serve different functions in the arbitration process. While the governing law of the contract determines the rights and obligations of the parties under the contract, the lex arbitri, or seat of arbitration, governs how the arbitration itself is conducted. Both are integral to the process but operate independently of each other. Selecting the seat is not a decision to be taken lightly. The parties need to consider several factors. Arbitration law. Is the jurisdiction's arbitration law modern and supportive of the process? Judicial system. Is the local judiciary experienced and supportive of arbitration? Neutrality. Is the jurisdiction neutral, especially in cases involving parties from different countries? And enforcement. Is the jurisdiction a signatory to the New York Convention? For instance, many international arbitrations choose seats like London, Paris, or Singapore because these jurisdictions have a strong legal framework for arbitration and are seen as neutral venues with supportive courts. In conclusion, The choice of the seat of arbitration is foundational to the entire arbitration process. It impacts the legal framework, the role of the courts, and the enforceability of the award. Moreover, understanding the difference between the governing law of the contract and the law of the seat is essential for navigating the complexities of international arbitration. Well, thanks for joining me today. Stay tuned for our next discussion where we'll dive deeper into other crucial aspects of arbitration.